You are listening to GN Radio UK.
Hi, everybody. You know, when you're relaxing in your car or at home, the radio station you should be listening to is GN Radio. Keep listening.
GN Radio UK.
Good morning to all our listeners. This is GN Radio UK Legal Hour with Abinelle Solicitors. The area of speciality is immigration law and family law. And then I'm not paying back when I drink como. Sewa bola keji and I drink como and I'm pay for Abinelle Solicitors. And to make sure, say, why you ready? Because, and I keep saying all the time, if you have an issue, don't sit there or think so because somebody has, because somebody has already encountered the same story, also at the same, also by encounter. Never make such mistake. And so for immigration law and family law, look no further than Abinelle Solicitors. All right? That's where you need to call. That's the people you need to get in touch with so they can help you. But before we commence with the show, let me put the details on. If you're watching live on Facebook, of course, the details are right there. Okay, you can't miss it. The details are right there. For the benefit of our listeners listening to us on radio, the office line is 0203 759 3309. 0203 759 3309 or 07824 705353. That's the mobile line. So you can call the mobile line again, 07824 705353. It's the number you need to call. The address to find them, to locate them, is 14 Claypole Road, Stratford, E15 2RJ. That's East 15 to Romeo Juliet. Okay? So make sure you pay them a visit. Now, let's get on with the show. Let's introduce my guest today. Sewa Bola Keji, thank you very much for joining us.
For having me.
Did I pronounce your name correctly? Is it Sewa?
No, so I'm Nigerian, so it's Shewa Bola.
Okay, I would have assumed that Shewa would have had an H in it, but it doesn't.
Yeah, it's a silent, let's say a silent H there somewhere.
Good stuff. Thank you for joining us today. Now, let's begin because I've been talking to some of your colleagues in the past, and people do send in their questions in regards to family law and also immigration. So let's begin. I have a question for you this morning. And the person is saying, I got married in Kenya in September 2018. My husband is a Dutch national. He lived in the UK for a year, and I relocated from Kenya to be with him in 2019 with my son, whom I had from another relationship. My son and I were issued a family permit from 2019 to 2023. He goes on to say, in 2021, my husband and I got divorced because he committed adultery. My child and I have our pre-settled status based on my relationship with my ex-husband. But this will end in 2023. I do not know what options are available to us since I am divorced. So if you can help them with this particular question. Sure.
Okay, thank you for that question. So there's still hope. There's still something that she can do for her and her son. They call this retain rights of residence. So she still has a right to actually stay in the UK. She's still considered a family member of her husband, even though it's her ex-husband. But there are a few things that she has to do. So this is under Appendix EU. It's where she can find all that information if she wants to do more research. Essentially, the main thing she needs to do is to show that there actually has been a termination of the marriage. So the main thing that you use for this is divorce proceedings. So maybe when she first initiated the divorce proceedings, maybe there was a letter from a solicitor sent to her husband to start the proceedings. She can show that. So,
that's fine.
So she can show that. Another thing that she can show. So yeah, as I was saying, so she can show that the divorce ended the marriage. The main thing is termination of marriage. So through divorce proceedings, or she can show the actual divorce certificate to show on this date, this marriage between me and my husband ended. Another thing that they want to see is that your husband was actually in the country at the time of the divorce. So he has to be living in the UK at the time that you guys got divorced. So the way they can show this is just letters to the house. So if they have council tax bills that shows within that year, your husband was in the house. Let's say she got divorced in January. So it will show January 2022, 2009, 2021, 2022. that he was still within the UK. It can be gas bills, electricity bills that has his name or both their names on it to show that he was in the country at the time they decided to get divorced. Another thing, one very important thing that they also need to show, they need to be married for at least 3 years. So I think she mentioned that they've been married since 2018, if I'm not mistaken.
Yeah.
So she has reached that mark to show that they've been married for 3 years. Another thing that she also needs to show is that she lived in the UK for at least a year. So I think she said they moved in 2018 or 19, 2019, I believe.
Yeah.
So she's definitely lived in the UK for more than a year. So if she has worked in the UK, she can actually use things like P60. That shows, you know, for the whole year you've been here. So from the time she came to UK and she started working, she can show all her P60s. She can also show council tax bills. Her name is on that. That would be perfect. Annual bank statements every year to show that, you know, she's been in this country as well. And that will definitely pass the 1 year mark. For her son, because her son, I believe, is not her ex-husband's child, so that will be his stepson. Her son still has a right as a family member, as her son. He still has a right under EU 14. So what they'll need to show is just that her son is actually related to her. So a birth certificate will show, you know, that's the mum. If they have a DNA test, that will also show that's the mum. And then letters from the GP to show when, you know, the son was registered. That will count for the years that the son has also been in the country. Letters from school to show that that's his mother. Even the GP as well, that she's registered as his mother. That will be very helpful to show, you know, the relationship between him and his mother. So all those things will be really useful for her, and she will still be able to retain her rights. Because she's not done more than 5 years, it would be a pre-settled status.
Okay.
If she had done more than 5 years, then she'd be able to actually apply for the settled status. So I hope that's been very
Okay. Just to remind our listeners that if you want to call in, you can do. The number is 0778 793 9958 or 0203 286 0185. So do make sure that you call. So I have another question here. And the question is, my mother is 67 years old and she's had indefinite leave to remain in the UK. She wants to naturalize as a British citizen. What are the requirements for her to apply?
Okay, her mother is 67. She's already got indefinite leave. Okay, so this is under the British Nationality Act 1981. There are certain things that you need to show in order to apply for your British citizenship. So one of those is that you have actually lived in this country lawfully for at least 5 years. So she's got her indefinite leave to remain, so she will, you know, qualify for that. However, she cannot exceed the amount of days. So it's 450 days within those 5 years you need to be in the UK continuously. They don't want to see a break in that. They want to see that, you know, you live here as you reside here for those amount of days. So you've not missed 90 days every year. So that would be the cutoff point. If she'd missed 90 days, if she's been out of the country more than 90 days each year, then that might be an issue. So they need to check that she, you know, has that. And like you said, she has indefinite leave to remain. So that's another thing. You actually settled in the UK before, so you can be through the EU settlement scheme or any other route. And she has indefinite leave to remain, which she qualifies for. And then they have the good character test. There's a lot of things that they look at with this one. Can't go into too much detail, but they will look at criminality. So do you have, you know, any criminal offences? Has she committed theft? Anything, maybe bodily harm against somebody else? Those are the things that they will look at. They will also look at if, you know, she was sentenced, for example, how long since she's done her sentence, how many years have passed after that. That could also affect, you know, her being able to apply for a British citizenship. They will look at if you've been involved in any terrorist attacks, for example, if you're part of any terrorist groups, they will look into that because they want the British people to be safe. So anything that's affecting the safety of the British people, they will really look into that and consider that in that application. Another thing is maybe she had a business, for example, and the business went bankrupt. They want to see that, you're someone that can look after your finances. You're not going to go into debt and bring other people along with you. So when it comes to bankruptcy, it's a business that's collapsed. It affects a lot of people. So they're going to look into those things. And there's so many other things that look into, if you've been a nuisance within the community, they might take that into consideration as well. And then the other thing that they also consider is the life in the UK test. So you have to do the life in the UK test. Fortunately for this lady's mother, she's actually reached the mark. So 65 years. If you're above 65 years or 65 or above, you don't actually have to do this test. Or if you have a disability, physical disability that will prevent you from physically being able to write the test, then that could also, affect you, and you won't be able to do that test. And then the last thing that you do, once you've gone through all of these stages, you need to swear an oath to the Queen to say that, you're a British citizen, so that's really the ceremony. But if she's able to reach these 5 things, then she'll be able to apply for British citizenship.
All right, I have a text message here from James. James is saying, I've been in this country over 20 years. I have my indefinite leave to remain. Do I still need to do the life in the UK test?
Yes. You would have to do that test, yeah. It's one of the requirements, unless he's above the age of 65, like I mentioned, so 65 or above, where he has a physical impairment where he cannot physically do this test. And they will also check these things to make sure you actually have that impairment. So it's only in those cases that they will not allow you to do the life in the UK test.
Okay, so this one, the person wants you to advise them on this. So the person is saying, I arrived in the UK in 2017. I have limited to remain based on my relationship with my husband, who is a British citizen. I recently renewed my leave and is due to expire in 2024. My husband lost his job during the pandemic and has really become abusive. He constantly threatens to send me back to Uganda, and he has seized my passport. He's always spending my money excessively and will not let me access to our joint account. I'm not able to do anything without his permission, and it's really starting to affect my health. I've become depressed and paranoid. It's starting to affect my performance at work. We had an argument. He said he wanted to end the relationship and left the house. He has not returned for about 6 weeks now. He messaged me on multiple occasions saying that he will send me back to Uganda and he will return to force me out of the house. So that's the background story. So the person is asking, is saying that I have no family here in the UK and no one to support me. I don't want to be homeless and I cannot return to Uganda. Please help me. What can such a person do?
Wow, this is a very unfortunate circumstance situation. I just hope no one, anyone else that's in that situation, there's always help. There's always something that can be done. So there's a lot of information there, but the general gist is this woman, she's been abused by her husband. And the laws actually protect, the immigration laws still protect people like this. So for her to extend her leave, she can actually apply under Appendix FM. They have a section called DV, which protects victims of domestic abuse. So the first thing that she would actually need to show is that she is legitimately married to a British citizen. So, and she got her leave through that relationship. So she can easily show this through the marriage certificate. She's still able to get access to that. That would be perfect. His British passport, she's able to get access to that as well. That will show that he's British and they're married. And then if she's finding it difficult to get these things, if she's got her leave already, like she said, she should have her biometric, biometric residence card that will show that she got her leave to remain under that route. and the letter she initially received as well would come in hand to also prove that she received her leave through her spouse, who's a British citizen. Another thing she needs to prove is the fact that she's actually being abused. So in her situation, she's not mentioned anything about physical harm. The main thing she's mentioned is, I think, intimidation, because he's British and she's not, so he keeps intimidating her, telling her that, he's going to send her back to Uganda. She still has a right. So what he's doing, he's actually emotionally abusing her. And I think she mentioned that he keeps using her money. So he lost his job, which is very important. But that doesn't, give you the right to, oppress somebody else. She doesn't have access to her accounts. So that's also financial abuse, which is still protected, under, domestic violence. So those would be things that she needs to demonstrate. The main thing I would say for her is it seems that her mental health is being affected. Mm-hmm. So she actually needs to go to the GP. She needs to, seek some medical, advice from the GP. And that will really help the application, because she can get a letter from the GP saying, that she's not even fit to work. She's been affected at work as well. She's not fit to work due to, the domestic abuse she's been receiving at home. And then that letter can be used in support of application if they give her any medication. So most times if someone is depressed, they normally give them antidepressants. So if she has that medication, she can show the prescription of that medication. That would be very helpful as well to application. Another thing, she's, going through abuse. So there are loads of helplines, loads of charities who, advocate for these things. They help women and men who are going through abuse. So if she can call, National Domestic Helpline, seek some advice from them, they will also be able to actually give a report, if she actually does an application and say, this woman has called us and actually complained that she's been abused and she's sought advice and, support. So that would be very helpful in her application as well, to show that, she's been going through domestic abuse and she seeks, refuge for some people. Another thing is, if she's afraid, I think she mentioned her husband keeps saying he'll come to the house and kick her out. So she's afraid for her safety. He could come anytime. She doesn't know what could happen. So I would advise to actually, call the police, your local police, and say, I'm afraid that my husband's going to come any minute here. I don't know what he's capable of doing. We have a history of him, being abusive to me. So I don't know what extent that could extend. The police will come, because they want you to be safe and feel protected in the community. They will write a report and they'll probably keep tabs and make sure, if any issues, if you reported it again, you're already on the system and they can issue you a report in support of your application. You just have to email them and explain that you just need a report to show that you actually called them. And in regards to just her protection, she can actually apply for a non-molestation order, which prevents people from, being abusive towards you. So if this order is granted and her husband returns to the house and he's abusive, he could essentially, go to prison for 5 years or be fined if he breaks that order. So that would be something that could really protect her while she's at home. And she can also use that in the application. The Home Office will look at that very highly. If you're able to get an order, in support of the application, they look at that very highly, and the police report as well. Most of the things I mentioned here are very strong evidence to show that, you're being abused. Another thing would be an occupation order. So to prevent him from coming into the house, you don't want him to come to the house and kick you out and force you out. I'm sure she's been paying bills herself. She has a right to be in that house. So she applied for an occupation order, which says that he's not allowed within the grounds of the accommodation. He's not allowed to access that house, and he's not allowed to live in that house. So those things would be very, 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 beneficial for her in her application. And she can also use it in general to make sure she's safe, getting the right support. But all these things will be helpful to show that she's actually being abused. So these are the things that they will look at within the application under Appendix FM, the DV section. And this application is actually free, so there's no cost attached to it, just because it's someone going through, something so drastic and tragic. So they've actually allowed the fees to be waived for that.
And with the non-molestation order, do you necessarily have to have your leave to remain to be able to apply for it, or it doesn't really matter?
Um, that's a good question. Because of the safety, I believe you should be able to apply for it because someone could essentially come into your house and harm you. But they still have a right to protect people, so it would be very important that they still apply for that, non-molestation order.
Okay. The next question is, my husband decided to file for a divorce and I want to oppose this. Will I be able to do that?
It's a very, very interesting question. I would say maybe a few years ago, this would still be, you'd be able to do this, but they've recently put in a law. So it's the Divorce Dissolution and Separation Act. It started in 2020, but it came into place in 2022, April. So with this, they've changed the old laws. So before you actually had to show fault, so it would be a fault divorce where, there's 5 grounds to why you wanted to get a divorce. So, for example, if you've been separated for 5 years, that shows that, you guys are no longer living together. You're not you're husband and wife in title, but relationally, you guys are not, romantic. There's nothing within the relationship anymore. Another thing also, if you've been separated for 2 years, that means you're living in different houses. Like I said before, there's no romantic relation, there's no association with each other. Those would be one of the things that you'd have to show. The third thing you'd have to show, so one of the things that you could show, if it applies to you, is desertion. So if your spouse just one day wakes up and leaves you, no contact, you don't know where to find them, those could be also one of the things that you could use when you're applying for a divorce. Another thing would be adultery, which might be one of the main ones. If your spouse has been unfaithful, that can be a ground, for you to get a divorce. And then the last ground that someone could have used would be unreasonable behavior. So they're just certain things that, your spouse has been doing that you consider very unreasonable. One of them would be being unfaithful as well. But whatever, you consider to be unreasonable, that would be something that you could put. So those are the 5 grounds. Unfortunately, those grounds no longer apply. So you don't actually have to show fault when you go for a divorce, which means that if you apply a petition for a divorce and, they notify the other person within the divorce, they can't actually contest it. So they don't have to respond, but then I think they give you about 6 weeks. If they don't respond, you can still go ahead with proceedings. So, your spouse could decide one day they want to leave you and get a divorce, and unfortunately, there's nothing you can really do about it currently.
Wow. Okay, so there you have it. Let me just put your details on, for the benefit of our listeners. Okay, if you want to get in touch with Abinelle Solicitors, the area of specialty is immigration law and family law. The office line is 0203 759 3309. Let me repeat that. 0203 759 3309. And for the mobile, it's 078 247 05353. 078 247 05353 is the number you need to call. Okay, get in touch if you have any issues regarding immigration law or family law or both. Make sure you get in touch. And I keep saying this because a lot of what we're discussing here is common in our society, and a lot of the times you hear one person saying, look, this is how this person did it, so you don't necessarily need to go and see a lawyer. Just go ahead and do it yourself. And there have been cases where people either have made the wrong application or decided to omit certain things or did not meet the requirement, and then what that happens is it just makes the process even longer. So do get in touch with Abinelle Solicitors, all right? Don't sit there and just think you can do things by yourself when it comes to immigration in particular. Okay, so do get involved. And if you want to call, the number is 0203-286-0185. The mobile line is 0778-793-9958. All right, let's get on with a few text messages, Shoa. So the person is saying here is all right. This is from a guy saying, my wife and I have not been on good terms and decided to separate. I moved out of the house last month into my own accommodation. We have 3 children, 2 boys and 1 girl. We both agreed that I could see the children from Friday to Sunday. According to the man, he went to pick up the children from school last week Friday, so he could have them for the weekend as agreed. He said when he arrived at the school staff stated that their mother said he was not allowed to have contact with the children, so they stopped him from taking the children. He says, I have tried on several occasions now to contact my wife, but she has blocked my number and I'm not able to reach the children. When I went to the house, she started shouting and falsely accusing me of stalking her. I am on my children's birth certificate and have taken care of them all their lives. What can I do to gain access to the children?
Wow, you see how people can go back on their words.
Yes.
So it's very important to have legal backing sometimes. Yeah. So in this case, very interesting case. He has a right, he's a father. Main thing under the law as well is his name is actually on the birth certificate. So that's a very good thing for him. What that means is that he has parental responsibility. So he has the right to make important decisions when it comes to his children. He has that right as a father. So he needs to be involved in their day-to-day lives. So what she's doing, she really shouldn't be doing it, but things happen when people separate. So in regards to a backing under the law, you could actually apply for a child arrangement order. So before, they used to have a residence order, so that decides where the children will live. And then they had a contact order, which will decide who has contact with these children, when they have contact, who will have them, during holidays. But now they've kind of combined it into one. So it's now a child arrangement order. But before he can do this, he has to actually go through mediation. So the courts and the law require you to first attempt, to have a civil agreement between, him and his wife before he goes through with court proceedings. So they call this a MIME. So he can call, any national mediation service.
All right. And I would just like to interject here quickly, Shoa. This is because we want you to log back out and log back in, okay? We're going to take a quick break as well. To our listeners, we're taking a quick break. When we come back, we'll continue with our discussion here with Abinelle Solicitors. We'll be back shortly.
When you thought you'd seen it all, but no, this is the height of it. London, wake up as the maestro, Mr. Music Man, the legendary Kojo Entry with Ketche and the Davison Band, UK. Live concert in the UK. This is happening live on the 30th of July, 2022. Time, 7 p.m. to 2 a.m. Hosted by The Force. DJ on deck, DJ TQ. Location, Gaumont Palace, Dominion Center, the Broadway High Road, Wood Green, N226DS. Performing live, we'll be having a surprise guest. Anticipate, come and witness history in the making. Tickets available online at www.kojoentry.eventbrite.co.uk. Remember, this is sponsored by Unity Link Money Transfer. Media partners. For more info, contact 077-288-76027 or 075-2552-48643. Kojo Entry with Ketche and the Davison Band UK. Live in concert. UK is powered by Davison Band and Desire Enterprise UK. So my guy, you have to there, eh? It's a legendary thing, my lad, me tell ya. Yeah. It's the anthem.
Losing someone is very traumatic, but it is more traumatic for people in the diaspora. It can be that you lose someone in the diaspora or you lose someone back home in Ghana. How do you meet the huge expenses associated? Air tickets, body repatriation, funeral service, unexpected bills, funeral director's bill, borrowing from the bank, or begging from strangers through GoFundMe. It does not have to be this way. Save yourself and your loved ones from the double trauma and embarrassment of bereaving and begging by taking a funeral policy with Diaspora Insurance. Their unique diaspora funeral cash plan not only does it allow you to cover yourself and your family in the diaspora, but you can cover your loved ones back home in Ghana on the same policy. Diaspora Insurance pays cash immediately, up to £20,000 upon claim to cover all funeral expenses. Please call now, +4477 0383 8304, or visit their website, www.diasporainsurance.com, to get a quote. Give yourself and your loved ones the guaranteed peace of mind they deserve. Diaspora Insurance is authorized and regulated by Financial Conduct Authority.
The world as we know it has changed, and so have the issues affecting our community.
COVID-19 and the geopolitical tensions have really made it abundantly clear that the African continent has to do more to be self-sufficient from an industrial capacity point of view.
Join me, John Sewa, on GN Breakfast Show as we look at issues affecting us here in the UK, with a close eye on trending stories across the world.
When we invest from the UK into infrastructure in African countries, that it is absolutely transparent.
With a focus on Ghana's social and political issues.
I mean, it's not about you thinking about, your money, the Sikadiya Basa, is not what our authorities should be thinking about, or officials, but rather they should think about the nation.
The Breakfast Show with John Sewa.
Monday to Wednesday from 8 a.m. on GN Radio. Welcome back to the program. We went for a quick break there. Now, before we went for a break, Shiwa, the question from a man who wants access to his children before him and his wife separated. They agreed on parental responsibilities, but it looks as if the wife has decided to go back on her words. And I think you were talking about mediation.
Yes, thank you for that summary. So, yes, mediation. Before that, I mentioned that he can actually apply for a child's arrangement order, which will put both contact order and residence order. So when you get to see your children, who they get to live with, how often you see them, the arrangements that you want in regards to maybe going to school to pick them up, all of those things would be under the child's arrangement order. So before you can do that, you have to go through mediation, which is where we stopped. And mediation, essentially, you have one person who will just be in the middle, They don't have any ties with any of you, so they're there to be unbiased, to listen to both your issues and help you come to a conclusion, to an arrangement. And after you guys do this, you can, have the arrangement in writing, so in a letter, and then you can both sign it. However, this is not legally binding. So if she decides again, I don't care for this letter, I don't want to see my children, she can do that. And the law won't do anything because it's not a binding document. It's just an agreement between, two people, and they've arranged it. So in regards to mediation as well, they can actually contact the other person on your behalf, and then they can arrange it. It can be on the phone, it can be via Zoom, it can be in person. So they're very flexible. But she does not have to attend mediation. If she decides that I'm not interested in this settlement, I'm not interested at all, she can reject it, she can ignore it, she can decline it. But it's up to you first to take that first step to attempt mediation. So once you've attempted it and she's declined it, that's what she decides to do, then you receive a document from the mediation service saying that you've attempted mediation. This document will be very useful for when you now go to apply for the child's arrangement order, which, like I said before, it can depict, who lives where, how often you see your children. It can also mean that when it comes to the school, for example, you can be registered. in school, so they know that this is their father. He has the right to pick them up on these days. You show them your order. If they don't agree, you say, look, I've got this order. It's all laid out here. I have a right to see my children and to have them during certain days. So what's good about this order is if she breaches it, you can enforce it. So what that means, you enforce the order, and then in the case that she breaches it, she can be fined. She might have to do community service. So no matter how many times she breaches it, that will apply. So it's very good to actually get it enforced, because then you have a legal backing. And I'm sure she would enjoy being fined on multiple occasions. Eventually, she would have to, agree. So that's what I would advise for this man.
I mean, it's important for you to clarify, because I happen to know a friend of a friend who's going through similar issues here. And so what's happened is, obviously I'm not going to put a name out there, but what's happened is they decided to separate. It's still fresh, and there's still a lot of animosity between the couple. However, the woman decided to stop the husband from having access to the children. Then after a few months down the line, she then decided, out of the blue, to finally give him access. Now the husband called the friend just to talk to him about it, and said that he doesn't know what to do, because at any given moment she could just change her mind again, and he'll be back to square one. So in this case, you would advise the husband to seek a legal backing or a document.
Yeah, I mean, he can come to us, we can help him.
Yeah.
But like I mentioned, his case is very similar, You have someone that says something and then they goes back on their word. It's very inconsistent. It will affect your relationship with your children. You don't even know what's being said to your children at this point. So it'll be very important. He still has to go through that mediation, just because it's something that they require. Yeah. But if the person is difficult, most times they won't go through mediation. They wouldn't actually accept it. He just has to prove that, I've attempted it. I have this to say I attempted the mediation. He can now go and apply for the child arrangements, which will put everything in black and white. Yeah. The order will be in place. So if she decides again to do this, he will enforce it and say, you know what, you're breaching this order, and this is what could happen. So yeah, that's what I'd advise for him as well.
Okay. Next question. My wife previously mentioned to me that she wants to travel back to Ghana with their children for a month. I'm not sure if they have left yet. Is there anything I can do to prevent this from happening without my consent?
Okay, I think is it the same man that's asking this question? It looks like it might follow from him. So yeah, in that case as well, he can apply for a prohibited steps order. So it's self-explanatory. It will prohibit her from taking the children out of the country without his permission. So like I mentioned with the child arrangements order, you can actually do this combined. So with the arrangements order, you will essentially outline all of the things that you want, from the order. Like I mentioned, the contacts of the children, responsibility, access to them. And then you can also include, this is what I don't want, this my spouse to do or ex-partner to do. I don't want them to take my children out of England and Wales, out of the UK without my permission. I don't want her to change their last names or change their name. You can actually do that. Oh. I don't want, if she has a new partner, I don't want this new partner around my children if you feel like, there might be some safety concerns, not just because you guys have disagreements and all that, but if there's actually some safety concerns, you can actually put this within that prohibited steps order. And if it's an emergency, so like you said, he doesn't know when they're going to travel, and he might be afraid that she actually bring my children back. So he can actually do an emergency order, which will not even notify her. But if the court believe that there's an issue in regards to the children and their safety and what's in their best interest, the court will grant it, and she will not, be allowed to travel without your consent. Yeah.
All right. So if you happen to be experiencing what we're discussing here, don't sit there in isolation. There is help out there. Abinelle Solicitors are there to assist you, to help you, okay? So don't just sit there. This probably be our last question. The person is saying, I'm a Ghanaian national who's living in the UK, but I have not received my indefinite leave to remain. My daughter was born in the UK and she's now 11 years old. How long do I need to wait before I can apply for my daughter to become British citizen? And how much does it cost? I'm not sure if I'll be able to afford it because I'm currently on maternity leave. Please advise.
Okay, so she doesn't have definite leave yet, but her daughter's been in the country for 11 years. She was born here. Okay, so in this case, her daughter can apply now. So under the British Nationality Act, Section 1, Paragraph 4, it allows someone who's under the age of 18, if they're born in the UK, they can actually, after 10 years or 10-year mark, they can apply to be a British citizen. However, like I mentioned with the naturalization, they can't have left the country. There's a certain amount of time. So 90 days each year that they've been, in the country, they can't miss that mark. So she has to make sure that she's actually lived continuously within those days and those years. But that shouldn't be a case if she's never traveled out of the UK and she's been born in here. She should be able to apply for her daughter to be a British citizen. I think the next issue is that she wants to know the cost and she's not sure she can afford it. So the cost is around 1,000 plus. They always change it, so it always differs, but it's 1,000 plus for the application. However, this year, they've actually decided that, if you can't afford the cost of this application, you can actually apply for a fee waiver. So that means is that you won't have to pay, luckily, which is a very good thing. But that being said, she needs to show that she can reach the affordability test. So with this, what they look at is, after all your essential, living costs have been paid. So you paid your rent, you paid for your gas and electricity, you bought the groceries for the children, paid all the things that are due. After all of this, do you actually have enough money in your account to pay for this fee? So that's what they'll look at. Can you even meet your essential living needs? Can you actually even provide food for your children or your child? They will look at these things. They'll look at your bank account. They will look at if you have a job. So like she said, she's currently not working. If she's receiving maternity allowance, that money is not that much. So it will not be able to, yet alone, cover essential living needs and then the fees on top. So she will be in a good place at this current point in time to show that, I can't actually meet, my own living needs. I'm not earning a certain amount of money. I'm in deficit, even if her account is always a minus. That is a good place to be in regards to the application. So she'll be able to have the fees waived and also hopefully get her British citizenship.
All right. Shiwa Bola KG, thank you very much for joining us this morning. It's been a pleasure to talk to you. Hopefully, all being well, we'll do again next week.
Yes, by God's grace. Right. Just remember our community day that's coming up on the 30th of July from 12 to 4 p.m. I believe the poster will be put up there. 41 Copperfield News, London, N18 1PF. You get free legal advice, free accounting advice. It's the time to just come together as a community. Let's learn from each other, get to know us, as individuals, as a company. We really love for all of you to join us that day. So thank you so much for your time today.
Good stuff. Looks like you've done this before. You've actually beaten me to it. Thank you very much. Thank you for joining us. So as Shiwa was saying there, Abinelle Solicitors wishes to invite you to their Community Day activity. They're saying come and join us for all your legal solutions. Free consultation with solicitors and accountants, free accounting and tax advice, free consultation, I should say, with solicitors and accountants, all right? Free accounting and tax advice, free legal advice, free food, free cold drinks. That's very important. The venue is at 41 Copperfield News, London, N18 1PF, and for Norman 18, 1pf. Okay. The date is 30th July 2022. Time is from 12 p.m. to 4 p.m. Don't be late, all right? Get there on time. Don't do the black people's time, the African people's time. Get there on time, okay? Because, you don't want to get there when they're packing up. That's not helpful. Get there on time. Buses to get to the location. Bus 34 from Walthamstow, 102 from Edmonton Green, 149 towards Edmonton Green, 144 to Muswell Hill Broadway, 149 towards London Bridge, Angel Corner, Silver Street Station. Okay, and by train, if you're looking to get there by train, it's Angel Corner, Silverton Street Station. So you have no excuse. Do get involved, get there, and make use of the services that they're providing on that particular day. Because under normal circumstances, these services being provided to you on a freely basis, you'll be getting charged for it. So take advantage and make sure you go to the event. That's it. We're done for another day. My name is Jones Ewa. This is GN Radio UK Legal Hour. All being well, we'll do it again, same time, same place next week. Until then, look after yourself and stay safe.
When you thought you seen it all, but no, this is the height of it. London, wake up as the maestro, Mr. Music Man, the legendary Kojo Entry with Ketche and the Davison Band, UK. Live concert in the UK. This is happening live on the 30th of July, 2022. Time, 7 p.m. to 2 a.m. Hosted by The Force. DJ on deck, DJ TQ. Location, Gaumont Palace, Dominion Center, the Broadway High Road, Wood Green, N226DS. Performing live, we'll be having a surprise guest. Anticipate. Come and witness history in the making. Tickets available online at www.kojoentry.eventbrite.co.uk. Remember, this is sponsored by Unity Link Money Transfer. Media partners. For more info, contact 077-288-76027 or 075-2552-48643. Kojo Entry with Ketche and the Davison Band UK live in concert. UK is powered by Davison Band and Desire Enterprise UK. So my guy, you have to there, eh? It's a legendary thing, my lad, me tell ya. Yeah. It's the anthem.